This program is brought to you by Emory University.
From the management side, one is from the employee side, and I don't really know whether they're not sitting next to each other and Richard's in the middle for a reason. But Pat is really just a very special person who's participated in the trial program, and I've got to know her over the last several years, and we've exchanged commentary, and she's extraordinarily thoughtful and certainly is a partner in one of the most prominent management side labor firms in the city. And Amanda Farahany, I've known for quite a while. She is equally amazing, and she's an expert on Title VII, and employment in her practice goes beyond the boundaries of Georgia. She's nationally known, and she can talk about a study that she did with regard to the employment cases going up to the 11th Circuit. And Richard Donner is actually one of the gems of the other side of the campus, and I thought that if we had this conference today, it would be good for him to, like perhaps Sadat coming to Jerusalem, Richard to come to the law school to see what goes on here, and if he likes it, maybe he can spend more time here, I hope. But Richard is a political scientist whose expertise is in industrial settings. So what I'd like to do is turn it over to Richard for maybe a 5-minute synopsis of what the current workforce paradigms look like. And Richard can give you a little bit of his background that can set that up, but limit it to, say, 5 to 7 minutes, and then we're going to have a dialogue about that.
Great. Thank you, Ruben. Is this on? I'm okay? So I'm, as was mentioned, I'm a political scientist, and I work on really the political economy of economic development in the developing world, but especially Southeast Asia. So I've been coming and going from between here and Thailand and Malaysia and Indonesia and the Philippines for about 35 years. And increasingly my work has taken me into the question of workforce development, vocational training, skills, and things like that. And that has led me to, and I also teach a course on politics of labor and development in the college as part of the political science program. And I've become increasingly interested in, let me make 3 general points, and that's what my interest is. I'm going to make 3 general points. One is the changing nature of today's workforce and employer relationships. Second is the problem that labor market institutions, including legal institutions, have not kept pace with the changing nature of the workforce and employer-employee relationship. And third, that these things have very significant, I think, political ramifications. So if we're thinking about sustainable growth, we need to take into account. First point, the changing nature of the workforce is probably obvious to all of you, and that is the growth of what is now known as a contingent workforce. We're talking about people who work in the informal sector, work in temporary contracts, work permanent but part-time jobs, work on unfixed, erratic schedules, move from workplace to workplace. And this is really a significant and growing trend, not just in developing countries, but even in places like Germany, where 20% of the workforce between age 19 and 35 are temporary. It's also occurring in Japan, Korea, as well as obviously here, and it's significant in China as well. And obviously this contrasts with a traditional workforce of fixed employment, clear promotion based on seniority, stable benefits, and things like that. So why does this occur? One is tremendous pressures on firms to be flexible in the face of turbulent markets and global value chains. It has also involved the rise of subcontracting, in which in many cases the final producer may deny or neglect responsibility of its own subcontractors. Professor David Whale from Harvard has now talked about the fissured workplace, one in which all kinds of functions of firms have been, that do not relate to its core competence, have been subcontracted. Another contributor to this is financialization, in which firms are, as was alluded to, are strongly pressured to address the needs of shareholders and to view labor as much more of a variable than a fixed cost. And finally, more and more attention has been paid to the idea of deindustrialization, the movement of people not to factories, industries, but rather to service areas that are traditionally been less protected and less organized. What that means is that workers are generally much more vulnerable. There has emerged a term in Europe, which now has kind of made its way here. The term is the precariat, obviously to be contrasted with the traditional proletariat. One of the problems, and here I'm drawing on the work of people like Catherine Stone at UCLA, is that labor law has not necessarily kept up with these changes. These changes do not conform to the traditional view of a bargaining unit. They don't conform to the traditional view of who is an employee as opposed to a contractor, et cetera. And my colleagues obviously can speak to this with greater authority than I can. Let me just conclude by noting a couple of issues that I think are important. One is that the vulnerability of this increasingly large group of workers lends itself to various forms of populist demagoguery. It used to be assumed that people who were insecure would move to the left. It's obviously not the case. It can be either way. It can be left or right. So we have problems in terms of the stability of our political system because of this. Second, and maybe more fundamental, is the ways in which this contingent workforce undermines the ability of people in the workforce to be good parents, to be good citizens, to participate in PTAs. That when you don't know what your schedule is going to be, when you don't know where you're going to be working, how long you're going to be working, with what kind of remuneration, with what kind of benefits, it makes it difficult to plan for the future. It makes it difficult to be a stable citizen in your community. So for me, that's a big political issue. Thanks.
So, Pat, I want to throw it over to you and ask this question about what is the obligation of the corporation to these contingent workers, in perhaps independent contractors or workers on the payroll of some leasing company, and maybe you could speak to a little bit about the debacle with the Browning-Ferris decision.
Okay, I'm not sure where to start with that, but I don't know if everybody's familiar with the Browning-Ferris situation, but that has to do with who's a joint employer, and the whole issue is can you have more than one employer? Talking about, as Professor Donner was speaking about, how traditionally you had one employer, that's who you worked for, and that's how we ended up with pension systems historically. We ended up with unionization because you had a stable workforce. The worm is turned, and so there's this concept that you could not only have what I kind of refer to as the gig economy, whereas you can have lots of different employers because you're just doing a gig, if you will, an Uber driver kind of thing. I'm gonna go out and I'm gonna pick up a case here. I'm gonna pick up a case there. We refer to them sometimes as independent contractors. But you can also have a situation where, and you find this a lot of times in franchise situations, where you've got the franchisee who you work for. Let's say it's a McDonald's restaurant, but that's owned by a mom and pop kind of group. They may own one restaurant. They may run 3 or 4, but the franchisor, which is McDonald's, calls a lot of the shots on how that restaurant has to be run. And so if you're a worker for one of those franchisees, you might bring a claim that says, I'm going to sue my direct employer, the person I see every day in the restaurant, but I'm going to also sue the big corporation, McDonald's Corporation, who franchises these things out. So on what we call the joint employer theory. And so historically there was a pretty stringent test as to who was a joint employer and who wasn't, in terms of who's really calling the shots and how much influence the big corporation had on the franchisee. And then with the change in administrations, the Obama administration came down with a decision under the National Labor Relations Board saying we're going to change the test for joint employer. We're going to, in essence, and I'm generalizing, but in essence, we're going to make it easier to prove that an employee has a joint employment relationship and therefore can get to the deep pocket than before. That was the law, Browning-Ferris, for a short period of time until the new administration came in and decided that they wanted to go back to the old rules, which they did for a very short period of time until that was challenged because one of the board members allegedly had a conflict of interest, and therefore that decision was set aside. It's called the Highbrand decision. So we're back to Browning-Ferris. I will tell you my perception of that is that that's going to be short-lived. As soon as the new board commissioner is appointed, he's been nominated, gets in, that's going to go back to the Highbrand.
So, I mean, really what we're talking about is you go back to 1935 and then the beginning of the National Labor Relations Act, and everybody knew who the employer was. You went to work for, United Steel, and they paid your check, and now the workplace is a little bit more complicated. You have these, I guess, multi-employer work settings. What kind of problems does this pose?
Well, in representing employees, it's who to sue to start with, but it's also whether or not there are laws that apply. So if you're talking about a McDonald's situation, for example, what an employee, what we're going to be looking at is there even laws to protect the employee? Because someone goes to work for McDonald's, they think they're working for a large corporation, then they're told they're being fired because they're pregnant. Well, you'd think that would be illegal. Well, it's not illegal in the state of Georgia, so you look to the federal laws that say you have to have at least 15 employees. Well, this McDonald's is a mom and pop, and they don't actually have 15 employees, so this person's out of luck. So, one side is looking, can you sue McDonald's, but the other side is looking to see, can you even count those employees to be able to say that this employer is responsible? On the flip side, you have situations like Uber and all the different apps that people are working for, and so then their question is that even an employer? And so that's being heavily litigated, because if they're an independent contractor, then the laws are not going to apply. So it becomes much more complex in deciding who's the responsible party? Is someone responsible? Are the laws even going to apply to be able to hold somebody responsible for what's clearly inappropriate conduct in the workplace? So it's confusing, and then you sue one person and they say, well, I'm not the employer, well, you're the employer on the paycheck. No, we're not the employer, that's actually this other person. And so you see a lot of that, and it goes back to, in 1935, you knew who you could go and who you worked for, and you had one employer, and you had the benefits that came with it, and there was a lot more stability in it. And so there's a lot less rights and remedies that people have today in being able to sustain a job, being able to have a job, being able to have the benefits that go with it, and also having corporations being held responsible for illegal and inappropriate behavior. So I think, from an employer standpoint, companies are much more likely to be able to make a greater profit, but that profit is really happening at the expense of people.
Okay. I'm going to throw out a question to the panel. I'm going to invent a company, Donner Department Stores. Okay. You're now selling high-class fashions. Okay. And like all department stores, you have various vendors who operate different parts of the store. So there could be, the Chanel section with Chanel employees, and Ralph Lauren, and the Percival section, which sells baseball equipment and so forth. Turns out that one of these vendors in this Me Too era is engaging in sexual harassment, okay? What are the problems, right, that this department store has? Does the department store say, hey, these aren't our employees, they work for a vendor, and walk away from it? Or does the department store implicate itself, as Pat might think, perhaps, in a joint employer relationship and say, that is our responsibility. We're going to go talk to that vendor about how they're dealing with the employees. And I'll throw it to each one of you. What do you do in that kind of situation?
Start with the employer.
Well, there's no question under Title VII that you have a responsibility if you're the employer, which is, a hurdle you got to get past, but that you have to protect your employees from harassment from vendors. It's not just from other employees or managers, but it includes customers and vendors and third parties. So that's pretty established.
Right. So you would, for example, look at, I guess, the Rogers case, which is cited in Meritor, which says that if you treat, and Amanda's nodding because I think she knows this, if you treat your customers adversely, that may have an adverse impact on your employees. So your perspective would be, to the extent that it's a vendor who's doing this sets the wrong culture for my own employees, or is there something more to it than that? And I'm still turning it over to you guys to debate this out.
Yeah, I mean, I think we're in agreement on this one, which is that if you are an employer, you're still responsible for the environment, the work environment. So if there's a hostile work environment that's created by a vendor, a third party, a customer, you still have the responsibility to remedy that, or you're responsible for the harassment.
I guess I would raise, so the focus has been on hostile work environment. What about issues of pay structure, scheduling, benefits, and things like that? Does that, so I'm ignorant of this, where does that fall in terms of a responsibility of me as the store owner and you guys as the vendors? Is it the same, presumably it's not the same set of constraints, right?
Well, I'm not sure I got the question exactly correctly, but for example, under the Fair Labor Standards Act, unlike Title VII, you can have an individual be liable. So the owner of the business can be sued under the Fair Labor Standards Act, whereas the owner of the business can't be sued under Title VII.
Yeah, and I think it depends who's employing, right? So is the vendor the one that's employing the individual? Are you as the store owner employing them? And then what is the integrated dynamics? So, I mean, I would take the position that you're both responsible for pay issues because you're a joint employer. And under the Fair Labor Standards Act, that's a broader definition of employer, whereas under Title VII, you're looking at the NLRA's definition of it. NLRA, yeah.
Yeah, under
Yeah.
the Fair Labor Standards Act uses really the IRS's definition of joint employer.
Right.
So it's
Or even employer. Yeah.
of employer, right? So it's a stricter standard.
So, I was intrigued because when Richard gave his introduction, one of the things he said is that the laws are not keeping up with these new workplace paradigms. And I guess I want to throw it to Amanda, and maybe this is a loaded question, right? Is it that the laws aren't keeping up, or is it the corporations or the employers are engaging in paradigms to avoid the written law?
So, I think probably it's three different issues. I mean, one, the law hasn't come to address what's going on in the workplace that's different. And the laws do not really change when it comes to corporations, not at least as it benefits employees. That is a very slow-growing area. I can't think of any major changes in the last decade or two even. And so I think, yes, smart companies are looking for ways to ensure that their profits are as great as they can be, regardless of the consequences to the individual. I also think that corporations are using that, but I also think that the courts are really limiting access to individuals as well. And so you have a limited set of laws, you have laws that are not progressing, and you have courts that are not enforcing the laws that are on the books.
Well, if I may, I think you've got to take into account the tension between what we'll call traditional corporate law, right? It, as an area of the law, allows for these corporate structures to exist, shell corporations to exist, parent corporations and subsidiaries and those kinds of things. I mean, that's the very essence, if you will, of corporate law. So there's a tension there between that and employment law, where you're trying to be able to say, I need to point to which corporation, should be responsible here. And so you want to avoid that tension of it's a shell game, the appearance sometimes of it's a shell game, which bean is under what hat. the bean being the poor employee who's kind of shuffled around. So from that perspective, I think there's some tension in the areas of law.
Let me just, one thing is just to keep in mind that these issues have come up in our own community, that some of you are maybe aware that several years ago there was a fight about Sodexo, and who was the food service. They eventually were asked that were dropped, and I think Bon Appetit now, but this came at the heels of all kinds of protest, and one of the things, and it's still going on, there's still question of compliance committees, oversight of Bon Appetit and things like that, but the issue of joint employment came up loud and strong at Emory. And one of the issues that emerged in the debate about all this was you had workers from Sodexo saying, aren't we part of your community? Whereas Emory basically said, you belong to Sodexo, we are Emory. We work with Sodexo, but you're Sodexo. And so I was struck by their discussion of community, because the little I know of law is that part of the definition of a bargaining unit is a community of interest. But the nature of the corporation as a community of interest has changed, right? You have value chains and subcontracting, which is quite different. And so how does the law catch up, whether it's corporate law or employment law, how does it catch up with that? That seems to me, this question, the way people talk about it is institutional drift, that the institutions have drifted away from the nature of the transactions today.
So, I mean, what Richard's talking about is you have a university, it could be any university, and they own a cafeteria or a kitchen, and they hire a contractor, and the contractor comes in and they use the same pots and pans and sinks and stoves that have always been used there. They're not necessarily bringing anything new. The only thing that necessarily is happening is employees are being put on the payroll of the contractor. And if that contractor is terminated, they'll go on to the payroll of a new contractor. And so I think what you were expressing is that these people in theory and are deemed to be part of a community, but they're not really part of a community, or at least they don't feel that. I mean, loaded question, I guess, for all of you, is that a good thing or a bad thing? I mean, is it good to have situations like that? Is it economically productive, or does it impair brand and reputation?
I don't know that that's a legal question, but, I think that's probably more answered from a corporation side. I mean, on one side, you see the benefit of having someone else be in managing over things, but again, it's the corporation versus the individual's rights that I think are different.
Well, I think when you started getting, I mean, corporations weren't the first people to do this. I mean, government does it. I mean, if you look at the private prison system, for example, as a country, we've got our government deciding an essential function of government, the prison system, I'm just not going to run anymore. I'm going to contract that out to somebody else. So it's hardly surprising to see corporations doing the same thing.
Right. But I guess the question is there a point, right, where you might say to your corporate client, it's like Chris Rock would say, you can do it, but it doesn't mean it's a good idea, right? And do you ever say that to a client? And are there other exposures or countervailing liabilities that would cause you to tell your client not to do it?
Well, there's always the component, if you will, of talking to your client about whether it's good for morale, whether it's good for your brand, whether it's good for your reputation. So you always have those conversations, I would think, in any situation where you're talking, whether it's environmental law, whether it's employment law, as to whether you're going to take a particular tact, whether you're going to go down a particular path in a decision-making situation. So am I going to contract this out? You're going to have those kind of discussions about the soft price of the decision.
So I want to change path a little bit, and I want to talk about Me Too, okay? And I want to start off, with Weinstein and so forth, and we seem to be in an era where we're realizing that there was a lot of sexual harassment that went untold, right? Perhaps discrimination in the workplace that was not identified, that was operating beneath the surface. I mean, tell me whether I'm right about that, And if you could elaborate on that, that would be great, Amanda.
So, I think from my perspective, no surprise. I mean, this is what I see every day. So I think the only thing that is a surprise is that more people actually understand what's happening in the workplace. Sexual harassment has been going on throughout history. It's no more today and probably not much less than it used to be. I don't know, maybe it's somewhat less than it used to be, but it's just a matter of people are talking about it. I haven't seen an uptick in the number of calls that we get, which, you know, most people think, oh, well, now that you have all of this that's happening, everybody must be calling you. But no, there's still the same risks that are in place for people to come forward and to make the complaints. There's still the same issues of people being scared to do something in their workplace. So we've been tracking it. Our numbers haven't gone up. The EEOC recently came out and said their numbers haven't come up. So I think it's more that it's a public conversation than it is anything new.
So
your perspective is.
When Eric McCarthy was on an earlier panel, he was saying that one of the things that a director has to do is inform himself, right? And so I turn it over to Pat. I mean, what do you see in terms of directors informing themselves and clients informing themselves about this?
I see them being scared out of their wits, and I do see that making a difference. Finally, they see it when it hits the front page, and they are afraid that they're going to be the next #MeToo. That gets their attention. And the other thing that gets their attention is when you talk to them about, for example, the case that was filed against the board of directors for breach of fiduciary duty. So that board was sued not for doing the harassment. They didn't do the harassment. The board was sued for breaching their fiduciary duty to ensure that it wasn't going on, because there was evidence that the board had information, credible information, that it was occurring and just looked the other way or didn't do the deep dive that our panelists talked about earlier today. So that gets people's attention. And in my world, that has gotten people's attention.
So now we've come full circle, and we're actually talking about the intersection of corporate law, right, and substantive discrimination law, which is really, really powerful. I mean, what kind of training do you do? What new roles do you have because of this as a lawyer, management lawyer?
I would actually ask you if the people who are scared are the ones who are not doing it or the ones that are. Because what I'm seeing and hearing just out there is that the people who are scared are the ones who have never had a problem but are now worried that, oh, well, if I tell somebody they've got a nice skirt on, or if I meet with the woman in my office without the door closed, that somehow I'm going to be the next victim of being accused of this, as opposed to the ones who've gotten away with it for ever and ever and ever are like, so what? I mean, I've always known I could be on the front page for this.
Well, I'm talking more about the boards than the actual harassers.
Right.
I think one of the things we have to be cognizant of, and I do talk about this with companies, is the pushback, the kickback that you don't want, which is going back to the days when I first started practicing law 30-something years ago. Men don't want to be around you. They're afraid to take a trip with you. They don't, and that's not helping women. I mean, that doesn't allow you to advance, to get promotions, to get the good assignments. If the backlash of this #MeToo comes full circle to, now, I can't be in the same room with you unless there's a witness, kind of thing. So I think we do have to be cognizant of that, and how do we deal with that?
I want to look at it from the vantage point of the court system. In order to bring a case in federal court, a discrimination case, one of the things the judge has to believe is, based on the facts, taking the conclusions out of the mix, that the case is plausible. And as to what plausible means, I guess it means the judge can bring in his own perceptions of human existence. Are these cases more plausible to judges these days? And I know you did a study somewhat on this area.
I did. So, and I'm doing another one too. So in 2013, we published a study showing how the courts handle discrimination in employment cases in the Northern District of Georgia, Atlanta. The whole Northern District. But what we found was that and it's as you explained it, which is that the judge is putting their own belief system into the cases and making decisions, which is actually unconstitutional, because the judges are simply supposed to be looking to see, is there a set of facts here that a jury could believe that matches the law here. And so they've, in my opinion, and I think what the numbers show, are at a very, very high degree throwing out cases that really should be a jury making a decision about whether it's not. So it's 90-some% of the cases were dismissed at summary judgment. The disparity was very great when you started to look at race cases. So, for example, a woman who brought a race discrimination case lost it 97% of the time, whereas a white male who was claiming discrimination lost 40% of the time. Sexual harassment cases, all but one was dismissed. And right now I'm doing an analysis of 2010 through 2017 using now machine learning and computer software and all of that to actually put these into analytics that will be able to produce them or on its own without having people do it. And the initial results, which I'm not 100% sure yet on, but seem to be correct, are that 100% of the cases last year were dismissed at summary judgment for sexual harassment. So, I don't know, I think that's a little high. But, you know, those are the kinds of things that we're seeing. So I think, yes, the judges are putting themselves in the place of a jury and they're deciding what they believe and what they think the work environment should be, and they believe that the work environment is one that is taking care of itself and that the corporations are doing the right thing and letting these cases pass.
So my question
No
was,
doubt
is Me Too going to change that?
I'm
And then I
hoping.
know what you said is probably going to generate some thought from your other two panelists.
Right, but I mean, that's what I'm saying. In 2017, 100% of the cases were dismissed, which is after Me Too started. So I mean, I haven't seen what's happened for this, last 3 months, but I don't see it having changed because I think the courts have created such a high standard to what is sexual harassment and what they say is sexual harassment that 100% are being dismissed.
Pat, I know you have a response to this.
I do. I think that, to answer your question about how people perceive the hashtag #MeToo situation, I think is going to make a difference because I think the fact that now people are more attuned to the fact that it's going on because of everybody coming out and speaking about it, I think it's going to make a big difference. I mean, they're talking about, like, for example, the Cosby retrial. It just couldn't come over at a worse time for him because it's going to be a huge difference between the first trial, which occurred before the hashtag #MeToo, and afterwards, simply because of people's perceptions. You can't unring the bell. I mean, people read the papers. And so I think that is going to make a difference.
I agree that if it gets to a jury, it will make a difference.
That's my point, if it gets to a jury. Now,
Right.
whether things should or should not get to a jury, Amanda and I do disagree on. The studies are what they are, but, those studies don't take into account what the merits of the cases are, whether these cases should have been brought in the first place, whether there's any merit to them. It also, when you talk about percentages that are thrown out or whatever, you also don't take into account the numbers that were filed and settled and those kinds of things. So I think those are skewed, but that, obviously Amanda and I agree to disagree on that, and that's no surprise.
Yeah, and that's actually what we're doing now with the new study, is taking the whole 8-year period, using analytics and computer learning to see if we can show the why behind it. When I did the study, I had myself not lost any cases at summary judgment for 7 years. And then for the next 3 years up until last year in 2017. And a lot of the arguments against the study were all the good cases settle early. These are bad lawyers taking bad cases, which, I found for the most part to be true for me, right? I'm taking good cases, I'm settling it. Last year things changed, and to put a little perspective on it, we're the largest firm that does purely employment law on the plaintiff's side. We have 15 lawyers. I own it, so I get to choose from the cases inside my firm. I have 6 lawyers whose job it is to actually talk to people, screen the cases, identify the best cases, set them for an in-person appointment. We then have a lawyer in-house who meets with that person, decides whether it's a case, and we've got a 3-lawyer decision-making process before we take the case. And then of the cases in the firm, I get to work on the ones that most interest me. And so last year, out of 7 cases that we had at summary judgment for the court, we lost 100% of them. So maybe it's not bad lawyers taking bad cases. I think it's fair for me to say I'm not a bad lawyer. I think we have a system in place that no other lawyers can put into place. And I can tell you none of those cases settled. The first one that is now on appeal, that we just argued recently, from the bench, the first thing that the judge said to me was, a very conservative judge, I think you deserve a reversal here. And I think maybe what happened, and he starts explaining why the courts below might have figured it out. That case was one in which my client worked for a Korean company. She wanted to transfer into another job. They told her they weren't going to give her the position because they wanted to put a Korean in the position. She complained, and a week later she was fired. The judge said no reasonable jury could find either discrimination or retaliation in that case. That's my personal experience for my first of 7 cases, and they go on from there. So, yes, we disagree, and I know from her perspective, and Trish and I have had cases, and she does resolve cases with me, and she's an excellent lawyer too, but we see it from a very different perspective. And I think that right there starts showing really what's going on. So if I can get this case to a jury, I'll win it. I have no doubt. There's not a person that I have told the story to that does not think that a reasonable jury could find that to be either discrimination or retaliation, except the 2 judges that ruled on it.
So I want to say that, when you teach discrimination in law school, nobody puts the corporate overlay on it. And at the end of the day, it's the directors of the corporation who have some obligation to investigate, stay informed, and make sure that their corporation's not engaged in deviations or derelictions from, of employment and labor law, because not only could it implicate liability, it could implicate problems with brand and reputation. And so, this was the notion of Edgar, which was that we would try to talk about these substantive areas and show the interplay with the obligations of the corporate officer and the director, and hence the notion of accountability. I want to throw it out to the audience to see if you all have any questions.
So what he's talking about is in sexual harassment cases, there's an affirmative defense that if it's not the alter ego of the company, or if the supervisor's not using corporate powers to take an employment action, that the employer has the ability to have an affirmative defense that defeats the claim if they have basically if they have a policy and the client didn't either follow the policy or the policy was followed and they remedied it. I thought that was actually a good place to go. I mean, it's all about whether or not a corporation's responsible when it first came out. And I think what's really happening is that the sexual harassment cases are being thrown out on whether it's severe or pervasive, whether it's actually sexual harassment, which like I said, the burden of that for a judge is far higher than what a jury would think. So it's never really getting to, or very infrequently getting to the affirmative defenses. So there are cases, for example, in the 11th Circuit that say things like one crotch grab is not enough. And so then the judges take that and say crotch grab and a boob look, or a crotch grab and a butt grab, or, and then it's become there's really nothing as sexual harassment. I mean, it might be a crime, but it's actually okay in the workplace. Am I wrong on that? The level that we have to get to?
I had a law partner once, years ago, probably 35 years ago, say, right after, you got this whole issue of we need a policy, and, we can put a policy out there and it's going to give us an affirmative defense and things like that. And I'll never forget it. He said, you can have all the policies you want in the world, but you're not going to stop heing and sheeing. And, I mean, that's going to go on. And I think the problem is the fact that that is a truism means where do you draw the line as to what's sexual harassment and what's not? And that is a tough line, but you can't, I mean, the statistics I forget are astounding on the number of people who actually met their spouse at work. So you can't start legislating out, I'm going to ask you out, and therefore, and if you say no, I'm going to be sued for sexual harassment. So we have to have a line somewhere.
I thought it was like grabbing someone without consent was the line.
Not necessarily.
Well, I'd ask one of you guys, labor employment experts, to talk briefly about the Ash Tyson case. Tyson, can you do that?
Yeah, this was the race case that went up and down and went and down. Very similar to the type of thing that I say, which is that the judges are putting themselves into the position of evaluating these cases. And so it was a race case. There was it nooses and the N-word, I think, was in it. So several different, pretty egregious things. And the judges would throw it out. It went to jury. Juries were coming back with 7-figure verdicts. It would go up to the 11th Circuit. 11th Circuit would say, no reasonable jury could find in favor. Kick it back down. It went up to the Supreme Court, and boy, was it issue. So is it, if you call somebody boy without saying black boy in front of it, something that a jury could find to be discriminatory? And our court said no, but the Supreme Court said yes. In fact, you don't have to say black boy in order for it to be discriminatory. And so sent it back down, at which point there was another trial and another 7-figure verdict and another appeal that was taken away. And I forget how it ended. But yeah, I can't imagine trying the same case 3 times and ending up with nothing. But I think it shows a lot of our circuit and our circuit's deeply ingrained beliefs that even all the way up to a fairly conservative Supreme Court, that they're consistently overturning. I mean, Farragher was an 11th Circuit case. And so you see a lot of the times when the 11th Circuit gets up to the Supreme Court that they're saying things like, seriously? No, yes, that's discrimination, or that's kind of craziness. And they don't quite say that, but they reverse and send it back down. And then our courts don't always listen.
We'll take 1 or 2 more comments if anybody has any questions. Okay, I'll turn it over to Richard for the last word if he has one.
Maybe make 2 points. One is that, that a lot of these issues from my perspectives are a function of some degree of mutual accommodation in the heels of various kinds of political power struggles. And so what we know about, certainly labor law to some degree, it's the result of decades of struggle, shall we say, of organization and struggle. So the question is, I don't think there'd be any reason to assume that the law is not going to change, wouldn't change absent those kinds of contentious engagements. And the question is, under what conditions can those in the workforce be able to engage in that kind of contention? That's one thing. And the second thing was just a question that I had listening to the previous panel, and that is the degree to which the question is, how do you compare firm sensitivity to environmental violations with labor violations? It's just a question, and obviously it's a big one, but I'd be interested at some point in understanding that, because I don't know much about it.
Well, I want to thank the
Can I just say one? I'm sorry not to let you have the last word, but to go back to this whole point of the integration between the corporation and the individual and the #MeToo thing. I think this I find really interesting, and that is that the New York Attorney General actually sued the Weinstein Company over some of the harassment violations. And the problem there was that the company had a multi-billion-dollar deal in the works to sell the company. And when the Attorney General filed that lawsuit, that deal fell through. So the corporation has put in place a situation to help the shareholders, to protect the shareholders, to sell the company. And we've got a purchase price here and a buyer. And the lawsuit queered that deal, so to speak. And then the interesting thing was the purchaser had put aside a good deal of money to pay the women who had complained. So when the deal fell through, the possibility then became the company goes into bankruptcy. those women then stand in line with the rest of the creditors. So, you know, my grandmother used to say sometimes be careful what you wish for because you might get it. So, you know, the AG got his lawsuit, but did he help those women? That remains to be seen. So I just thought that was kind of an interesting intersection between the corporate, the same thing happened in the New York Met. I mean, you know, with the conductor who was accused of harassment, and the Met did their investigation. They fired him and washed their hands and said, "See, we've done all we need to do as an entity. We got rid of the bad actor," and the hue and cry, it was not so fast, Gomez. That's not enough. We want the board gone, and the board for the New York Met are volunteers. They don't even get paid. And the hue and cry was, we want everybody gone. So I think those are the kinds of things that you're seeing now that are affecting the corporation on a different level than simply, I'm going to get rid of the bad actor.
Well, the issues that we've been talking about today obviously have drawn a lot of passion and emotion, right? And people have different perspectives. But for me, it's been a very powerful experience because people have been honest about it, and this has been at least a forum for people to, you know, have an academic, intellectual dialogue, and we hope for that. We hope that people would engage in rigorous debate, that it wouldn't be, you know, left versus right, talking heads on CNN. It'd be people with real-life experiences wanting to do the right thing and solve problems, which are obviously very complicated. I want to turn it over to Lorenia, the editor-in-chief of EDGAR, who will be graduating this year and has done just with her staff, the managing editors and all the board members, has made this year of EDGAR the best year ever, and I want to thank her for that and give her the last 2 seconds.
Really quick,